When you represent someone and you would allege negligence, as you were talking about in your fourth example as an example, or any number of cases, I guess you're suing someone because, well, frequently because it might be negligence. Who defines negligence? Who would say, whether it's the consultant, as you were talking about, or in some other case, who is to say on that question of negligence that there was negligence? Is that the court ultimately? But even as far as just the bringing of a suit, how do you determine if someone was negligent to bring a suit to begin with?
Well, negligence has long been defined as what a reasonable person would do or would not do under the same or similar circumstance. And that's a general good definition. In that scenario, that's what we have to prove in a court of law. There's precedent through other cases, and when lawyers look at determining whether to file a claim or not, they do it with the eye of looking under that standard, that definition, with whether or not they can prove the claim. And I'd just like to add that we've heard the phrase frivolous lawsuits for years and years, and trial lawyers do not file frivolous lawsuits. We can't afford to. We're going to hold a case for 3 or 5 years. It's a long time.
Is that a typical holding period?
Yeah, absolutely. Maybe longer. And we're going to spend an awful lot of money trying to get justice for our clients. It is not unusual for a trial lawyer in a complex case to not only hold the case for 3 to 5 years, but to put in anywhere from $100,000 to $300,000 of our own money into a case on behalf of our clients to make sure that we can potentially prove their case. So if we're going to work on a case for 3 to 5 years, and our office overhead, I'm a small businessman too, continues to run with salaries, my insurance costs, my rent, neither me or any trial lawyer wants to end up on the losing end of a case that shouldn't have been filed. It's not in our interest. Now, the reason that our fees are often contingency and that we charge a third is because, and I say this to my clients frequently, I say the insurance company lawyers are getting paid $250 to $500 an hour. And at the end of every month, they send a bill to the insurance company for $5,000 to $10,000. Would I be able to send you a bill at the end of every month, despite the fact that you're hurt, you're not working, you got medical bills, you got bill collectors after you, and I'm the lawyer now who you hired to seek justice for you is sending you a bill for $5,000 to $10,000 at the end of every month?
So you're going to take cases, one would think, I don't want to put words in your mouth, but you're going to assess the case as a business person and as a lawyer and say, is there a reasonable expectation that you can win a case based upon the facts as they were presented to you and whether or not there were negligence? So I think you would say that you're not going to take cases where you don't perceive there to be negligence, otherwise you'd end up wasting your time and money.
Absolutely. And the trial lawyers are against frivolous lawsuits. And we've always been. Hang on one second, if I may.
Go ahead, sure.
I just think that the word frivolous, it goes both ways. And what the public never hears about are frivolous defenses to legitimate lawsuits. And the public never hears about the fact that when there are legitimate cases filed, that oftentimes the insurance companies will file defenses that are frivolous. And cases go on for years in an effort to wear down the plaintiff into accepting less than fair compensation. And I can show you a significant number of cases, which we have here at the trial lawyers, where these frivolous defenses, where cases are settled after years on the courthouse steps that should have been settled years before and resolved. And the public never hears about those frivolous defenses. And I think if the public were to read the examples that we have and what really goes on in the court system at times, this word frivolous goes both ways.